Thank you so much for joining us today. This is an endorsement interview with Attorney General Ellen Rosenblum and her opponent, Michael Cross. And I'm Helen Jung, I'm the opinion editor for the Oregonian. I'm wondering if we can just start off by having each of you give just a brief introduction about who you are, why you're running, and why you think voters should choose you. And if we can start off perhaps with Ellen, if you wouldn't mind going first.
Absolutely, thank you. And first of all, my heart goes out to all who are dealing with evacuations and concerns about the fires that still continue to be a big problem for our state. So I wanted to start with that. This is such a fraught time for Portland and for Oregon, for our country, and frankly, for the whole world. So I'd like to talk about why I'm running for a third term as Oregon Attorney General. And it's because I think I have the skills that are uniquely suited to this moment. And really nothing could be more rewarding or important than to put those to work for our state right now. So in the face of these challenges, whether they're the wildfires, the pandemic, the summer of protests, I'm going to offer a few things that I think distinguish me perhaps from my opponent and make me feel like I am ready to continue to serve. First, I believe that I have deep legal skills that have been honed over decades in private practice, as a federal prosecutor, as a state and trial court judge, and for the last 8 years as Oregon's Attorney General. Number two, I have a very collaborative approach to problem solving. Look at the work that I've done during these past 2 terms, organizing task forces in areas like public records, hate crimes, police profiling, consumer privacy. And I've worked across the aisle. I've worked with Republicans and Democrats. I've worked with law enforcement and the defense bar and with advocacy organizations. And I've brought them to the table. And we've had remarkable success at the legislature because of the way that we've gone about this. Third, I have a wonderful legal team. Just look at the work that we've done in protecting the governor's emergency orders, just as one of many examples. Fourth, I have a very strong work ethic. My day begins at 7 a.m., lasts until midnight, at least 6 days a week, and my teams will tell you that I'm actively engaged in the work of our department. During COVID, although we've been teleworking, I have meetings every morning with my staff for an hour to make sure my most closest circle for an hour in order to make sure that I know exactly what's going on and how to proceed with the rest of my day in terms of meetings, in terms of projects, et cetera. And then once a week, I meet with my executive team, which is the heads of all of my 9 divisions, all on Zoom or on the phone. We've become very nimble in that regard. And then the final thing I wanted to mention is the support of attorneys general across the country, whom I've led both as chair of the Conference of Western Attorneys General, which is a bipartisan group, and as co-chair of the Democratic Attorneys General Association, which I continue to co-chair after a good 5 years or so. I've kind of lost track. And this means that Oregon has a bigger seat at the table in multi-state litigation. It has also put me in a position to be Oregon's first line of defense against the unconstitutional conduct that has occurred with this federal administration. Right now, I'm very concerned about the ways that the president is interfering with the electoral process, as an example. And if this president is reelected this fall, the role of Oregon's Attorney General is going to take on even more added importance. So in this current moment, I feel that the most important role I can play is to lead and to support others, to support the governor in her efforts to guide the state in these difficult times. She and I just spoke yesterday morning about just all the ways in which I can support her in this time. The People of Color Caucus in their efforts at the legislature to craft effective legislation to reduce police misconduct, to address economic inequality, and to fight institutional racism. And of course, the people of Oregon. I like to think of myself as the people's attorney. I sometimes even call myself the mama bear because I really believe that I am here in this role to protect people, to do consumer protection, and to make sure that I'm looking out for the most vulnerable, and particularly when it comes to frauds and scams. I believe this sort of work, after all, is what good lawyers and leaders are all about. So those are, I'll stop there, the main reasons that not only do I hope to be supported to receive the endorsement of your newspaper, but also to be elected by the people to be able to continue this important work. Thank you.
Thanks very much. Michael, would you like to tell us a little bit about yourself and why you're running?
Sure. So Michael Cross here. Our website is michaelcrossfororegon.com, and I honorably served our country in the United States Air Force. And so I as of course a part of that, I swore an oath to uphold and defend the Constitution of the United States against all enemies, foreign and domestic. And I just see some things going on. I love Oregon that I find frankly, very alarming, and wanted to do my part to put us back on the right track, I believe. And well, the incumbent stated that, she supports the governor and things like that. And I think a little too much. She's a little bit too supportive of the governors, and we need to have that inherent checks and balances that our founding fathers had instilled in our founding documents. And what's healthy for a good republic is to have a separate branch of government that's, respective of the will of the people, and not so much, who the governor is or what the governor's doing, or, but holding actually that person accountable, whether they are the same political party or, a different political party, hopefully, and this is one of my skills, is that, I call out things when I see it. I find, issues with things, even if it's in my own party or somebody else, and it doesn't, it's irregardless of, political affiliations or anything. I mean, we are of the people, by the people, and for the people. And I feel that that's lost. And, I think that, as she refers to herself as a mama bear, and I think that, the folks up in Portland would have a, very much in disagreement with that. And, and there are many people in Portland that don't feel safe right now. So, I mean, in my prior, my background, a little bit of my background, I have worked for myself most of my life, actually, from childhood. And I had my first checking account at the age of 12. And most recently, I've been the president of Super Green Fuels. We work on, alternative energy and things like that to lower carbon emissions and these things. But I've been a managing member of several companies over the decades of my professional career. And so I have that thinking outside the box kind of, how do we get it done on a limited budget and sharpen our pencils and shave that dollar to be most effective and efficient to achieve the goal. And in this case, I believe that the goal needs to be in instilling law and order back in Oregon. And, many people, it just drives me nuts when they talk about what's going on in Portland as riots. I mean, excuse me, they're not referring to it as a riot. It's not a demonstration, it's not a protest. And I will zealously defend everyone's First Amendment freedom of speech, but you are not doing that when you are, kicking somebody in the head. The demonstration there is that they're a punk and they need to be locked up. And, what about the rights of the people that live in the Portland area and they don't even feel safe when coming out of their homes? I also have a solution to the homeless problem that is out of control. The governor ships them from one part of the state, buses them down to Medford or various other, areas. And, that's not right. And it's just getting worse. And my solution to that harkens back to the CCC program about 80 years ago, which is the Civilian Conservation Corps. And so I do have a solution for the homeless problem, and it involves people like our partners in, Nike, Intel. The trades are screaming for help, and it's like and I was also bring in nonprofits that are very familiar with dealing with addiction issues. Unfortunately, this segment of our population, invariably they seem to have addiction issues of either drug abuse and or alcohol. Programs that are very much proven, such as Celebrate Recovery, Narcotics Anonymous, Alcoholics Anonymous. And so deal with all of those issues and then train them, carpentry and plumbing and electrical. Even the apprentice level pays such a high, wage. It's a living wage, and that's crucial, I think. And you know, and then what's going on with the fires, and it's like, oh my gosh, and it's, you know, pardon my appearance. I've been helping some friends that have been, you know, evacuated from the fire, so I apologize for my appearance. But you know, I mean, why is it that this isn't being covered? We have numerous arrests for arson, and yet, you know, I mean, what is Ellen doing? I mean, is this yet another form of demonstration that they can burn down Mill City? I mean,
so
we
let
need to
me
hold
ask
people
you.
accountable when they break the law. I mean, people are dead or they're in the ICU for third-degree burns. It's incredible.
So there have been stories about arrests related to some of the fires, but I guess I'm
Jackson
wondering,
County Sheriff and
right?
yeah,
And I guess
arrest.
and so what are as AG? I mean, what do you think the AG should be doing at this point in the situation when it appears that things are, you know, the police agencies are doing their job? It'll go to the next step. I guess what is the role that you think that you as AG would be doing?
Well, I think that that she's already set the tone that's adversarial to law enforcement, and that when she filed the lawsuit to prevent the law enforcement in Portland from wearing protective gear and preventing them from making these arrests, and of course she lost that suit. But you know, it's a dangerous precedence to do that, and so I think that number one, you know, this needs to be fairly reported in the media that these are arson. I mean, I've got pictures of their booking records and with their photo and the fact it says felony arson. And so I would hope that Ellen is extending to local law enforcement investigative tools and the resources to, you know, track these people down. I mean, and you know, hold them accountable. It's crazy.
If I could just add,
Sure.
Michael and Helen, we do have a very active DA and law enforcement assist program, and we reach out all the time. We're actually helping with the investigations of some of the alleged arson and other types of serious crimes that have occurred in Portland recently. So we are helping with the Portland Portland Police Department investigations, and we are absolutely available. We reach out all the time. Every district attorney, every law enforcement agency, we work very closely with them, and they know that we will help them if they request that we do so. I just want to make sure you know that.
And in closing, I mean, you know, the other thing that's driving me to run for Attorney General is that, I mean, no, I'm not saying it's Ellen's fault, but you know, forcible rapes are up 60% and assaults against women are up 40%. And you know, if this recent federal lawsuit that she filed is any indicator, then I think that would, you know, that speaks volumes as to what's going on there, and that these you know, criminals need to be prosecuted. They need to be, you know, hunted down and not being allowed to, you know, harm other people, women. You know, it's not right.
Can you I'm curious if you can tell me a little bit more about the statistics and where they're from, and how it relates to, and I presume it's a lawsuit against the Trump administration regarding the federal law enforcement involvement in towards protesters. Is that what you're referring to? I just want to make
Oh,
sure
you
I.
mean the rioters, towards the rioters?
Mm-hmm.
They're rioting. This is not a protest. I mean, when businesses are closing and people are getting hurt and threatened, that's what are they demonstrating exactly? That they're thuggery? I mean, that's
Well,
not
I think there were some stories
society.
regarding people being pulled off the street. There was the protester who was standing with a speaker who was fired upon with an impact munition and took a hit to the head. But you know, rather than go into that, I guess I want to understand a
Yeah, and
little
there
bit
was a man
more.
shot and killed too.
Right,
Young
right,
man, yeah.
certainly. But what I'm trying to understand is the statistics you were referencing and just how they connect to the lawsuit.
No, there's no connection. I'm just saying that was another reason for me to step up and become the next Attorney General.
Okay.
We're becoming a very dangerous state. That's quite clear to me.
Okay. I'd like to move on to, you know, a very big issue that has been the focus of a lot of attention on the city, state, and federal level, and that's the question of police reform. And specifically, for instance, earlier this year in the first special session, the legislature considered a bill that would task the AG's office with investigating incidents or allegations of use of excessive force by police that resulted in death or serious injury. I'm curious, and why don't we start with Michael on this? What is your position on that bill? Do you think the AG should be the one to take the lead on investigating those cases?
Of police brutality or excess force being used?
Right.
Well, absolutely. I mean, if somebody needs training, in a certain area, then I think that needs to be made available, and everybody needs to be held accountable, whether you are a protester or you are a police officer in a responsible and law-abiding society. We need to all be held accountable for our actions. And hats off to those gentlemen and ladies in professional law enforcement, because they have a very tough job. And, but I believe we have probably the best system in the world and the best judicial system in the world, but it's not perfect. And that when errors are found in somebody's performance or in the court system or something like that, then it needs to be addressed, very, very quickly, because in my mind, justice delayed is justice denied. And again, I do believe we have probably the best system in the world, but it's not perfect, and we do need to make it better.
Okay, and so you would support the idea of having the AG's office be the body that investigates, those complaints?
Well, I mean, I think it would be more efficient to me to hold that accountable at the county level, and that the AG's office oversee the various counties in their, I don't think that needs to come from the state level. And if a certain county isn't stepping up and meeting that need, would be to get together and meet with them and find out what's going on, where we can improve in that area.
Okay.
So I think it should be handled at the local level first.
Okay, thank you. Ellen, same question for you. Basically, should the AG's office be the one to take the lead in investigating allegations of use of excessive force by police?
Sure, we've been working closely. My office has a legislative policy director and myself actually directly to explore the potential for a law change that would give my office more authority than we currently have. We currently have authority. I think that needs to be clear, that if the governor or the district attorney ask us to take on that responsibility, we will do it. And we do that very often, not so much in the use of force cases, but in many types of cases, certainly in connection with in kind of public corruption type cases, that sort of thing, where there's obvious local potential for conflict, if not outright conflict. And certainly that is a concern. And I think that's why there's been this sort of opportunity in conjunction with the protests, in conjunction with many other proposals for laws relating to police accountability and reforms, to give my office greater responsibility here when there is what appears to be a conflict, where there's an incident that occurs in the local jurisdiction, where if as great as our DAs may be, they nevertheless have to work so closely with local law enforcement, and yet they're going to be investigating the very people that they work with day in and day out, and it can be extremely awkward and uncomfortable. And so often, as things currently stand, it's fairly rare for the district attorney, him or herself, to actually handle the case. They'll often bring someone else in, but it might be a neighboring DA, or it might be just in the conjunction with the investigation, but not the prosecution. You mentioned investigations. I think that does make sense to have an investigation done by an independent agency. And if at the end of the day, the legislature decides that it should be my office, I welcome that. I have not requested it specifically to date in previous sessions, but I've never taken a position against it. And I am going to continue to work with the caucus, with the committee, the Joint Committee on Transforming Policing and on the use of force, to make sure that whatever comes out of the committee and goes to the legislature is something that's workable, that we have resources for. Frankly, we don't have the resources right now to be able to take that on necessarily, as at least not all cases of use of force, perhaps cases that are specific to death. But if you broaden that, we're talking about many, many more cases. So again, want to make sure that if we do take that on, we have the resources to handle it.
And following up on that, and why don't we start with you, Ellen? Are there any other specific roles that the AG's office should take in pursuing police reform on a broader scale?
Well, there's also one of the co-chairs of the committee has requested a look at a Colorado law, which is a law that provides for civil authority for the Attorney General on patterns and practice of civil rights violations by law enforcement or by anyone for that matter. So that's a law that we are starting to take a look at. It's, the way they draft, every state has a different way of drafting its laws. Some are much broader and frankly vaguer, more vague than ours. And so when we took a look at it, we were like, whoa, what does this really mean? It seems really broad. So we're going to be taking a look at that at the request of Representative Bynum, and happy to do that because I think that that is an area, particularly with the federal government doing so little in civil rights, frankly, at this point, we need to fill in, some of those gaps, and we're available to do that. And I think we would be good at it. And again, we would need the resources to be able to do that.
And Michael, same question for you. Are there, okay, oh, sorry. Same question for you. Are there specific, other specific roles that the AG should take on in terms of helping with police reform on a statewide level?
Well, I mean, we need to make sure that we, everyone's treated fairly, regardless of their color, their religious beliefs, so on and so forth, and obviously have accountability to, our men and women in law enforcement. And we need to make sure that, that there's not corruption going on, but I mean, I don't know. I mean, my focus is to reduce the recidivism rate. And I mean, we have the highest incarceration rate in the world. And I think we need to analyze, why is that? Why are these people, in other words, so take a step back and look at it more globally and analyzing, why are the police needing to be involved in these people's lives as much as they are? Why are so many people locked up in prison? What's going on, and what can we help these families to get the tools that they need to keep that family intact, rather than, when issues do come up, when challenges do come up, that invariably results in, a police call or things like this, and to give them the tools to do that. For instance, there's an administrative rule that allows for an inmate that is within 90 days of being released, that if he or she can demonstrate that they have a job and a place to live, that they would be released early. And I would think that up to 90 days early, and it's never used. It's never used. Why is that? So maybe rather than building more prisons, we need to encourage these people to, give them the tools, and certainly, having a place to live and having a solid employment, the minute they walk out those gates, is going to make them become a more productive member of our society. And I think that needs to be the focus, rather than, the other part about the police. And, though not minimizing that in any way, but we need to look at, why is it that we are the highest incarcerated, in the world?
Great, thank you. In terms of, one of the roles of the AG, the AG oversees public records appeals on a certain level. And sorry, I'm mixing up two questions here. Let's start with this. How well do you think, and I'm sorry, this would start with Michael, how well do you think the state's public records laws are working?
Well, and that was one of the things that we needed more of, and that was promised, was transparency coming out of the executive branch. And it's just not happening. She quit, the person in charge of that for the governor quit. And I think that a good and unbiased attorney general is going to look into that and investigate, why is it that public records person quit? And, we alluded to earlier, me being a staunch, advocate of the First Amendment rights, but all the rights. And I'll zealously defend, you as a reporter. I have spoken with some reporters, and this is something that law enforcement needs to change, is they like to shoo away the reporters from a crime scene, you know, and there are certain things that they cannot obviously report, and I get that, but we need to have freedom of the press and this kinds of things, and you know, we definitely need more transparency. You know, we the people of Oregon need to know what the heck is going on in that Marble building, and what these people's, you know, what these meetings are, and all of that. It needs to be vastly improved, in my opinion.
And just to follow up on this, and I apologize because this is what I was also trying to get at, do you think that there needs to be changes in terms of accessibility to police officer disciplinary records, or really disciplinary records of public officials in general?
Oh, absolutely. And I would also love to see, you know, when judges' decisions are overturned at a higher court, I think that those need to be made public, that what the decision was and what the judge was.
And
you know, on appeals.
Right. And your feeling is that those are not made public?
Well, not so much. I mean, unless it's a big splashy story, and you know, there's no mandate that these records be made public. But I think that any time that a judge, you know, it'd be nice to have somewhere on the website at the AG's office where they could go and see. So then if we do see a trend of a particular judge is more often than the norm being reversed, then we need to take a look at that.
So is it basically you would want it collated and maintained at a certain site? Because appeals are posted on the Court of Appeals website, the Supreme Court's website. It states who was a judge, et cetera. It sounds like you're kind of looking for more of a centralized location for people to look that up.
Because, I mean, your average person doesn't know where to find that, and I think it needs to be more accessible. And, you know, the other thing that I've seen is, you know, and there have been several, you know, you talk about Black Lives Matter, Black lives do matter, but it's not always at the street. What about if they're falsely convicted of, say, murder, and then they've lost their entire, they're locked up, incarcerated. And there was a Marion County judge, I think it was Judge Tripp, that wanted this happened to be a Black man, have his case, you know, this man needs a new trial. She was very familiar with the case, and I would not interfere with the circuit court judge deciding that give the man his day in court. If a circuit court judge thoroughly reviewed his case, which she did, then he needs a new trial. And, you know, again, justice delayed is justice denied. And Ellen Rosenblum delayed that new trial and you know, appealed that decision, and he spent an additional 8 years in prison. He's finally released, but that's not right. And that's not fair. You know, Black lives do matter, and that's wrong. You know, I'm very strongly about it. And
Ellen, if you might be able to respond to that, but I'm also interested in your answer to public records law, how it's working as a whole, but also specifically, is there something to do more on police disciplinary records?
Thank you, Helen. Yeah, I don't know that I can respond specifically to the case that Michael raised, so I think I'll just go directly to the question. You know, I led the public records reform task force several sessions ago, and that was one of the examples I gave earlier, because I'm really proud that I was able to bring together a very broad-based group, lots of different interests, and we were able to come together and make some proposals for reform that did pass the legislature that session, along with the governor's proposal for a public records advocate. We now have a public records advocate once again, so I'm glad that we have that individual in place, because it's very important. And I felt really, it was very unfortunate that we lost our first one under those circumstances. But what we did with the task force, I think, was an improvement, a big improvement, but we're not where we need to be. So one of the improvements is the timeline. I think we now have some actual timelines that must be complied with by the agency that the records are requested from. I think things have sped up, but I'm not sure that they are, you know, quite where they ideally should be. The other thing we're doing and there were a number of other reforms that I think were certainly progressive and positive. But now we have another committee called the Sunshine Committee that is very hard at work, although it's been a little bit tricky during COVID to have meetings, but we have been meeting. And that committee is reviewing all of the many, many hundreds of exemptions in the Public Records Act, the Oregon Public Records laws. And we need to do that. It started out in the early 1970s when the law passed with something like 60 exemptions, and we're now up to somewhere, you know, upwards of 400. That's just not okay. So we need to consolidate, we need to delete, we need to do all kinds of things but it's going to take time. And so there is a committee that's working on that. As for the issue of police records, I just want to give you my creds on this. Back in 1976, I was a young lawyer, and I actually represented the ACLU in a lawsuit that we won under the then pretty much brand new public records law. And it was about releasing closed police investigations. So it involved the Douglas County District Attorney. It was called Jensen v. Schiffman, and it's still a case that's cited today. And I was the young lawyer on that case. And I was honored to get to represent my boss, David Jensen, who was the ACLU representative, or plaintiff. And it was about, you know, what happens when a police investigation is over? Are those records available? And the answer I believed then, and I believe now, and what the court agreed with is yes, except for under certain, you know, special circumstances that are comparable to the federal law. So it basically adopted the federal law. So I just wanted to be clear that I am oriented towards transparency in police records, from the disciplinary records of the police all the way through the investigative reports. There's no reason to keep those hidden.
Great, thank you. I think we start now again with you, Ellen, and I wanted to talk about non-unanimous juries. The Supreme Court earlier this year made clear that non-unanimous juries are no longer, that it is not constitutional. And your office had filed a brief arguing that the 1972 decision in Apodaca should not be overturned. Can you talk a little bit about why your office took that position? And actually, let's start with just that.
We felt that it was important for the Supreme Court to be aware of the circumstances in Oregon. This was not an Oregon case. This was a Louisiana case. And so we wanted to be at the table and make sure that the Supreme Court was aware of that Oregon was also kind of a part of the scene on the issue. We were in fact, we were the only state remaining, the last state standing that had still had on the books non-unanimous jury instruction. So that's why I participated. But I would like to talk about the issue, if I could, in a little bit more depth, because I want it to be understood that I then and still now wholeheartedly support ending non-unanimous jury verdicts. So I applaud the decision in Ramos, and my office is now acting expeditiously to carry out its mandate. But I think it's really important, Helen, to bear in mind that this whole situation is much more complicated than it may first appear. So if I could spend a couple of minutes explaining to you some of the various things we're doing and the kind of, we call them the buckets of cases, and forgive me for using that term, but it seems to work, like this bucket, that bucket. There's certain types of cases that fit into different categories. So first of all, we're putting the thousands of criminal convictions that are involved in these buckets due to clearly differing circumstances. And we are working in collaboration with the courts, particularly the appellate courts, and the defense bar, the criminal defense bar, to deal with them. And we're attempting, frankly, a challenging balancing act, because there's a strong policy, public policy, favoring the finality of criminal judgments. And there are the rights of victims in Oregon that are constitutional rights. And there are, of course, the rights of criminal defendants that are constitutional rights, which have gotten, by far the most attention, which is fine, which is fair. The first bucket or type of cases that we have to address now, and I think it's important, we're post-Ramos at this point. So we have to address involves criminal defendants who were convicted by a non-unanimous jury, and they had direct appeals pending when Ramos was decided. Okay, and again, working in collaboration with the defense bar and the courts, we've asked our appellate courts to send more than 200 of these cases back for retrial. Okay, and the courts have agreed to that. The courts have to agree. This is not just up to me. If I concede something, the court has to hear it and understand why I would want to concede that and decide on their own whether or not that is the right thing to do. And in these cases that I just mentioned, that has happened. And so then there's, excuse me, I'm sorry. There are also cases on direct appeal where juries were unanimous, but the defendants convicted by them now say that the unanimous verdict was tainted by the non-unanimous jury instruction. Okay, that's a bucket of cases. And there were arguments on that a couple of weeks ago before the Oregon Supreme Court. Then there are thousands of living convicted criminal defendants who have served their terms, but they're no longer incarcerated. Okay, so that's a different bucket. They're not incarcerated, they've served their terms, they've been convicted, their direct appeals are over, but they want to have a new trial. Okay, either because it was a non-unanimous jury or because it was unanimous and they feel their verdict was tainted. So they need to file for post-conviction relief. And the trial of their issues are going to be handled by the local district attorney, not by the Department of Justice. So that's another bucket. I don't decide what's going to happen with those cases at the outset. I might decide on appeal if those do go up on appeal. But at this point, they would be for trial by the DA, any of the 36 counties. Then there are the thousands of criminal defendants in prison today whose direct appeals were over when Ramos was decided. As you know, there's about 14,000 inmates in prison today, right? The Oregon prison population. Some of these, 600 so far, have filed for post-conviction relief post-Ramos, okay? Somebody said it was around 50. Somebody said they thought it was gonna be 40. It's already 600, okay? And that's on top of the 200 that have been sent back. Okay, so these are the ones that we do handle, and these are the cases where we, given the considerations of finality of judgments and the rights of victims and defendants and such, we're briefing these issues for the court, along with the defense, or sometimes called the PCR bar, the post-conviction relief bar. And then finally, you might not have even heard of these, there are also criminal defendants who pled guilty after entering into plea bargains. And some of them are saying the non-unanimous jury instruction is the reason that they did so. And so they want to rescind their plea bargains. And these we have not formally addressed yet. Phew. So those are the primary buckets, if you will, of the different types of cases. And I think it's really important to understand that, because this is not a simple matter of up, down, yes, no, moral versus immoral. I do feel there are moral, practical, and legal reasons why it would be irresponsible for me as Attorney General to be acting unilaterally in asking that these cases be retried, independent of courts, the legislature, and the people of Oregon, just being me, the Attorney General, making that decision. And just to speak to each of those, morally, because retrying every case could cause significant harm to hundreds or thousands of victims of violent crimes and their family. Practically, because in a great many cases, we no longer have living witnesses who can testify, or it's been so long that they can't really be expected to provide testimony, and evidence and records may not be available. And this was part of what we presented to the US Supreme Court, getting back to your question, in our amicus brief. We try to explain that we had relied for, since 1972, when that same court, as you know, said it was constitutional, right? That non-unanimous juries were constitutional. So we've lived with that for 48 years, since 1972. My first day of law school, or just before, I think, ironically. And then finally, legally, in Ramos, several Supreme Court justices said the case would not be applied retroactively, and none of them said that it should be. So they signaled that it wasn't the issue in Ramos. So I'm not saying they decided it, but they signaled that they would not anticipate that it would be applied retroactively. So that is the reason that the very capable lawyers in my office, my Solicitor General, Ben Gottman, and others, believe that the law as it currently stands in our country and in Oregon does not support sending older cases with final judgments back for retrial. So even if we were to concede that all these cases should be sent back for retrial, and we're not conceding that, our appellate courts actually might not accept that position. There was actually a case last year that Justice Walters wrote, State v. Vallon. And she made it clear in that case that the court wants these complex legal issues to be briefed for its determination and not simply conceded. It didn't involve Ramos, but it was another issue that was similarly complex. So I wanted you to know that for that and for the other reasons that I've stated here, I am comfortable now having the Oregon and the United States Supreme Courts make this determination about the effect of these cases, about retroactivity, about whether Ramos is retroactive such that all the cases I just described to you potentially could be returned for trial, many of which won't be able to be retried. Let's be reasonable and fair and you know, just common sense. It's not going to be possible. So we're basically talking about overturning many, potentially thousands of convictions, which is what I've always said. I always said it could be hundreds, if not thousands. That's what I said at the beginning. It turned out to be true, even though there were those who said, oh, it's only going to affect, you know, maybe 40 cases. Well, we knew that wasn't right. Anyway, under the rule of law, I believe that this is as it should be. This is how we're going about it, and that it's the responsible thing to do here in Oregon. So that's my spiel on non-unanimous juries. And I understand that there's all kinds of differing opinions about this, but I'm not sure too many people actually have heard about all the different types of cases that need to be considered and that will be considered in some kind of order. It's trying to be done orderly. I have to tell you that once again, I feel like having an attorney general who knows how to collaborate, who knows how to work with others, who's been a judge, frankly. I've been a judge, both a trial judge and appellate court judge. I gave this instruction. I gave this unconstitutional instruction hundreds of times. And it's very upsetting to me to think about that now, and that, you know, that I couldn't have done really anything about it at the time because it was the law. It was the law since I was a first-year law student, all the way through the 22 years that I was a judge, Helen. And now it's not, and I'm very glad it's not.
Thank you, and I really appreciate the detail that you went into. I have not heard that kind of explanation about the array of cases in front of the state. So that's very helpful. I appreciate it. Michael, on the issue of non-unanimous juries, I mean, you know, I think we have a sense of some of the complex decisions that are before the court. Do you have a position in terms of how the DOJ should proceed on some of these cases that are considered closed, you know, don't have aren't under direct appeal, or for instance some of the other buckets that she was talking about?
Well, clearly, I mean, I appreciate the explanation from Ellen. It was kind of the long way around the horn, lots of buckets going on, and clearly it's a civil rights violation, and it's tragic and it's disgusting, frankly. And Ellen has had 8 years to put pressure on the legislature to change it and has failed to do so. And it harkens back, frankly, to Jim Crow laws. And, you know, either are we virtue signaling that Black Lives Matter, or at the end of the day, do they really? And that's why it's in place. And there's only a handful of states that do that. And it's shocking and disgusting that Oregon has that, you know, in our own backyard, this is going on. And so I believe that these cases need another look as soon as possible. And how that happens, this is obviously, it's a mess, but I mean, it's paramount to me that, you know, in my view, is when somebody is being, you know, charged with something, they're in the court system and winds its way to trial if they don't settle, and is that the law itself is on trial as well as the defendant. And all too often that's forgotten, and it's tragic, and we need to change it as soon as we can.
Okay, thank you. I'd like to move on to just some of the changes to Measure 11 under Senate Bill 1008, which gosh, that was last year that I passed. It's all kind of blending together. There were two cases in the past year in which teens were either sentenced or charged, where teens were charged with horrific murders and were either sentenced or processed as juveniles as a result of the changes under SB 1008. Is this law working the way it should be, or do you think that there need to be revisions at the legislative level? And Michael, I guess we would start with you on this one.
So I'd have to familiarize myself more with it, but are you talking about where they got rid of the death penalty in certain?
No, so this would be basically juveniles from 15, 16, 17 who are accused of Measure 11 crimes previously would have automatically been treated as an adult. Under Senate Bill 1008, it's now supposed to be an individual determination of whether a juvenile should be charged as an adult. However, there were two cases, one in Lane County and the other in Yamhill County, I believe, that were pretty brutal murders. And in one case, the judge discussed at length how it sounded like he felt like his hands were tied in terms of making a determination that the teen would fit the requirements to actually be charged as an adult. So I guess that's, stemming from that, I'm wondering if there is a need for additional changes at the legislative level.
I mean, I would want, if somebody's 16 and charged with a horrific crime, why is it that person did that? And because it's horrific does not necessarily mean that they need to be considered an adult. At 16, they're not an adult. And, so it's good at filling the prisons, and that's a good business to be in for some folks, but that's not going to benefit society all the time. And we need to look at what's going on in that child's life, what caused this to happen. And, there's nothing we can do to bring the deceased back. And it's tragic no matter how you look at it. But I think charging a 16-year-old as an adult is probably a mistake.
Thank you. And Ellen, same question for you. Do you think that there need to be changes on the legislative level to Senate Bill 1008?
I haven't heard of any proposals yet for those changes, Helen, and it may be that I should have if there are any. But I would say this, look, I was a judge before Measure 11 and I was a judge after Measure 11. And so what that means is that I actually started out in 1989 when I was first appointed as a trial judge, having the discretion that we now have, that judges now have. And then we lost it and it went to the DA. Okay, so the DA got the discretion, not the court. I believe judges should have that discretion. Now, whether I would have taken made the same decision that these judges made about whether the child should be prosecuted in adult court or remain in juvenile court, I don't know the answer to that. And I may actually be handling those cases if they come up on appeal. So I'm going to be I would probably be circumspect anyway, but I will just say that I don't know so much that there needs to be changes. It's fairly new still. I think we're still working through it. Obviously that gave people some pause, like, whoa, is this what the new law is about? Maybe this went too far. I would not assume that. I would simply say that we certainly need to take a look if there is some kind of a loophole or something that made that judge feel that his hands were tied, if in fact maybe they weren't. That is something we need to look at.
And you believe that the standard in the law in terms of, and I'm not going to remember the exact wording, but the having the, I think it was the sophistication or the understanding of what they were doing, that the law has enough leeway built in that a judge should be able to move someone into adult jurisdiction.
I think so, but I will agree that it's difficult. It's a very difficult standard to work through. And so I think maybe that, I don't want to criticize a judge, but especially having been one myself, but it may be that we haven't, because it's still new, that we just haven't really worked through what that really means. And I just can't speak to what that judge took into consideration. I don't believe that it should require, just at first blush, and I may change my view on this after, if there is a proposal, and I'll certainly look into that, but I don't believe that it's a legislative change that needs to be made. I think it may be more, something else. Perhaps there's expert testimony that needs to be explored, and it can be very expensive. So for the courts to really do the job that they need to do in order to, not just the courts, but for the district attorneys, for the prosecution to make the case that child actually, cannot be, I know the words, I can't think of them either, but the words that lead to the decision that, basically they're hopeless. They're not going to ever be safe, even though their children and their brains are not totally formed in terms of their maturity. And, there's just so much research, so much evidence on that now, but it's unclear whether in this particular case that have been sufficiently evaluated and presented.
And I want to ask you something, Ellen, about specifically for you. Your office challenged a redistricting initiative campaign that was granted a lower threshold for gathering signatures due to the coronavirus pandemic. Why did you decide to step in on that measure?
We stepped in on that. It had nothing to do with what the substance of that measure was. It just so happened to be the redistricting measure, which a lot of people support, and it made it seem like it was a political decision on our part. It was not. It could have been the next measure. It could have been the one involving the proposed secession of 7 or more counties from Oregon to become part of Idaho. So we don't look at it that way at all in terms of what it was. It was more the issue of the judge, one federal judge, deciding that he could amend our state constitution as to not only the deadline, but also the number of signatures that are required by our state constitution. So it really is a matter to me of states' rights, and also an argument that the Constitution, the U.S. Constitution, does not require what the judge did in that case. So we appealed, we won, and it ended up that matter, because of the timing, not because of anything we did, but other than to go through the normal appeal process, the timing did not permit it to be on the ballot. Perhaps it will be in the future. And personally, I don't take positions on any ballot measures. I will say, however, that I have taken the position against partisan gerrymandering, and I've written a brief. I took on the Wisconsin case, and our office wrote the brief, and we got, like all the Democratic AGs to support it, I think, or most of them, at least 17, as I recall. And we're also supporting the constitutionality of this very measure, IP 57, in another context. So I just wanted to be clear that it wasn't a political decision on my part at all.
And Michael, let me also ask you, you don't have a law background, and in terms of your management experience, nothing on that level regarding overseeing the AG's office. What would you tell voters to assure them that you are ready to step into this position?
Well, I think that's actually my best quality, is that I'm not a lawyer. And, our founding fathers of our state wisely made it so that you did not need to be a lawyer. And obviously I believe there's some wisdom in that decision, and it's been there for so many years. And I would contend that, perhaps maybe why we have so many of these problems is because it's not just a regular person in there that has, business sense about things, and, a heart that's compassionate and, non-biased as to political affiliation and all of this stuff. So, it seems what's been going on is woefully inadequate. And if, credentials were the solution, I think that Ellen would probably have it. But the facts and the statistics bear out that, we have been going down the wrong path the last 8 years. Crime is up against women across the board, the rioting, these things, the fires, and you know, that these people that if they are the same ones rioting, think that they can get away with this is unconscionable. And, you know, it's just, it's tragic and sad, you know, and I'm interested in serving Oregonians, and that's what needs to happen. And the person that has been through the you know, the normal things in life, that, you know, faces these things, and you know, like with the non-unanimous juries being okay. I mean, that's wrong, you know, and yeah. So I think my business experience and everything else makes me more than qualified for the role.
Thank you. Let's see, and I don't know if you guys want to have a ending statement or just wrap things up, but if there's anything that we haven't addressed that you really want to emphasize, or any parting words, why don't we start with Ellen, and then Michael, you can have the last word since I think Ellen went first. So.
Okay.
Great.
Thanks, Helen. Well, I found this a very interesting conversation, and it was really good to hear what Michael's reasons for running for Attorney General are. I do think it needs to get straight that the governor and I are in the same branch of government. We're both in the executive branch, and I represent her actually as her lawyer. So when I say I support her on, for example, her executive orders, that's part of my job. And I think it's important to understand what the job of Attorney General is, and to have legal background in order to do it effectively. But as far as my priorities for the future, for the next 4 years go, I just want to remind you that my goals are to hold powerful bad actors accountable. I have quite a record there. To defend Oregonians' rights and well-being. I also have quite a record there over these past 8 years. And to continue to stand up for the most vulnerable, which I will do. And I appreciate the support that I've received over the years from a very broad spectrum of Oregonians. I'm proud of the support that I have, and I look forward to continuing to serve. Thank you so much for having me. And I would love to have the endorsement of the major newspaper in our state.
Thank you very much. And Michael.
Thank you for having me as well, Helen. And it's been a very engaging, interesting conversation, I feel. And I think that Ellen's statement answers some of my questions as to why this is going on and why we're going down this path. I mean, she stated that she represents the governor, and I disagree, because if she represented the governor, then that would be an appointed position. Instead, it's an elected position by we the people. So I believe that an effective attorney general represents the people, that gets the individual into office. And it's an important, integral part of our state governance to have checks and balances, you know, holding each other accountable. They are in the same branch, but her constituents are who she works for, not the governor. And I mean, that would explain to me why our pandemic response and how that's just being, you know, terrible. The CDC has reduced their mortality rates by 94%. So it's no longer 168,000 dead, but more like 8,000 dead. And in 2008 in H1N1, we had about 500,000 people dead. And this is costing people their businesses, their jobs, their lives, their homes. The stress is through the roof. This mask mandate is ridiculous. And Ellen Rosenblum is not holding the governor accountable. I would do that if elected in there, because this is not a game. It's not funny, and it's tragic. And I too hope I get the Oregonians' endorsement. Thank you.
Thank you. There were a number of things that you mentioned just then that I would like to perhaps follow up with you on, just to find out a little bit more about just kind of where's you know, the death rate, for instance, and other things, but we can do that offline. But I do want to thank you both for taking this hour to talk with me.
One other thing.
Sure.
Ellen, I would like to see if you'd be interested in a debate.
Happy to talk offline, Michael.
What's that?
Happy to talk offline. I don't think that would be appropriate to discuss in an endorsement.
You don't want to
interview.
debate me?
Well, I think it is, we have gone over, and I would like to just kind of wrap things up, but thank you very much, both of you, for taking
Thank
the
you.
time
Thank
to be
you.
with us. And
Thank you, Helen.
I will let you know when the endorsement is going to be coming out. Thank you.
All right. Thank you so much.
Appreciate it.
Bye-bye.